Good day to each and everyone, especially to sir. Now I'm going to narrate the Rule 130, Rules of Admissibility. So Section 1 of Rule 130, the Object as Evidence. Object as evidence are those addressed to the senses of the court when the subject is relevant to the fact in issue. It may be exhibited to examine or viewed by the court. Section 2 of Rule 130, the documentary evidence. So documents as evidence consist of writing or any material containing letters, words, numbers, figures, or any modes of writing expression offered as subject of their contents. So Section 3 of the Rule 130, the original document must produce exception. When the subject of inquiry is the contents of the documents, no evidence shall be admissible other than the original document itself, except in the following cases. First is when the original document has been lost or destroyed. B, when the original documents is in the custody. C, when the original document have numerous accounts. And D, when the original documents is the public records of the Section 4 of Rule 130, original documents. The original documents is one, the contents of it which are the subject of inquiry. B, when a document is in two or more copies of executed at or about the same time with identical contents, all such copies are equally regarded as original. C, when an entry is repeated in the regular course of business and being copied from another. Section 5, Rule of 130. When original document is unavailable, when the original document has been lost or destroyed or cannot be produced in court, the offerer, upon proof of its execution or existence in the cause of its unavailability without bad faith on his part, may prove its contents by a copy or by a recital of contents in some authentic documents, or by the testimony of witness in order stated. Section 6 of Rule 130, when the original document is in adverse party's custody or control. If the document is in the custody or under the control of the adverse party, he must have a reasonable notice to produce it. If after notice and after the satisfactory proof of its existence, he fails to produce the document, secondary evidence may be presented as in the case of its loss. Section 7 of Rule 130. Evidence admissible when original document is in a public record. When the original of a document is in the custody of a public officer or is recorded in a public office, its contents may be proved by a certified copy issued by the public officer in the custody thereof. Section 8 of Rule 130. Parties who calls for documents not bound to offer it. A party who calls for the production of a document and inspects the same is not obliged to offer it as Section 9 of Rule 130, evidence of written agreements. When the terms of agreements have been reduced to writing, it is considered as containing all the terms agreed upon and there can be between the parties and their successors in its interest. No evidence of such terms other than the contents of the written agreement. So first, the intrinsic ambiguity, mistake, or imperfections in the written agreement. B. The failure of the written agreements or the express the true intent and agreements of the parties thereof. C. The validity of the written agreements. Section 10 of this Rule 130, interpretation of a writing to its legal meaning. The language of a written is to be interpreted according to the legal meaning it bears in the place of its execution unless the party intended otherwise. Section 11 of this rule, instrument construed so as to give effect to all provisions. In the construction of an instrument where there are several provisions of particulars, such as construction is, if possible, to be adopted as well given effects to all. So section 12, interpretation of according to intention, general and particular provisions. In the construction of instrument, the intention of the parties is to be pursued, and when the general is and a particular provision are inconsistent, the latter is amount of the offerer. So the section 20 of the Rule 130, the testimonial evidence, qualification of witnesses. Witnesses, their qualification, except as provided in the next preceding section, all persons who can perceive and perceiving can make known their perceptions to others may be a witness. Section 21, Rule 130, disqualification by reasons of mental incapacity or immaturity. The following persons cannot be witness: those whose mental condition at the time of their production for examination is such they are incapable of intelligently making known their perceptions to others. So second, the children whose mental maturity is such to render them incapable of perceiving the facts respecting which they are examined and relating them truthfully. So section 22, the Rule 130, disqualification by reasons of marriage. During their marriage, neither the husband and nor the wife may testify for against to other without the consent of affected spouse, except in a civil case by one against the other, or in a criminal case for a crime committed by one against the other, the latter's direct descendants or descendants. So section 23, Rule 130, disqualification by reasons of death or insanity of adverse parties. Parties or assignors of parties to a case or persons in whose assignators of parties to case or persons in whose behalf a case is prosecuted against the executor, administrator, or other representative of deceased person, or against person of unsound mind upon a claim or demand against the state of such deceased person or against the persons of such deceased. Section 24 of Rule 130, disqualification by reasons of privileged communication. The following persons cannot be testified. A. The husband or the wife during after the marriage cannot be examined without the consent of other as to communicate, receive, and confidence by one from other during the marriage except in a civil case by against the other. This is the Rule 131, burden of proof and presumptions. So Rule 131 Section 1, the burden of proof. Burden of proof is the duty of the party to present the evidence on the fact in issue necessary to establish his claims or defense by the amount of the evidence required by the law. So Rule 131 Section 2, conclusive presumption. The following are the instances of conclusive presumption. Whenever a party has by his own declaration, act, or omission intentionally and deliberately lead under to believe a particular thing about true and act to upon such belief, he cannot in a litigation arising out of declaration or act of omission The tenant is not permitted to deny the title of his landlord at the time of commencement of the relations of landlords and tenant between them.